ready to start when you are, Vyapak and Raj.
Sure. I think it's 4 o'clock, so maybe Sahil, you want to kickstart?
Sure. Thank you very much. So, good afternoon, Justice Patel, Sitting Judge, Bombay High Court, Justice Wazifdar, former Chief Justice, Punjab and Haryana High Court, Senior Counsel, Dr. Saraf, Honorary Secretary, Bombay Bar Association, ladies and gentlemen. I'd like to welcome each of you to the e-launch of the Indian Arbitration Forum's Best Practices Guidelines for Conduct of Arbitral Proceedings, version 2.0. Now, before we jump in, a couple of housekeeping items are mandatory. May I request each of you to switch off your video feed and keep your audio on mute? And number two, questions, if any, may be posed only on the chat window. They will be addressed during the course of the session. Now, moving on, as many of you may know, the Indian Arbitration Forum, or IAF, is an association of leading arbitration practitioners committed to streamlining the conduct of arbitration in India. The guidelines were prepared with a view to provide guidance on evolving best practices in the arbitral process. IAF partnered with Combar UK and were in association with SIAC, MCIA, as well as the Gujarat National Law University, GNLU. The IAF guidelines were the result of a 5-step process. Number 1, research of existing international guidelines. Number 2, preparation of a questionnaire to understand the gaps in the Indian arbitration practice. 3, interviews with domestic and international practitioners. 4, drafting of the guidelines. And 5, a broad review of the guidelines. To reconcile the international best practices with the existing realities of arbitration in India, a questionnaire was prepared for the purpose of interviewing practitioners. This checklist was prepared with the assistance of Jasbir Dhillon, QC, Rajesh Pillai, QC, and Rebecca Zaman. The IAF then identified prominent domestic and international practitioners who would be interviewed for the purpose of this exercise. These included Mysore Prasanna, Jasbir Dhillon, Annalise Day, QC, Ketan Parekh, Senior Counsel, Nakul Diwan, Sharina Pettit, and many, many others. The initial draft was reviewed by legal luminaries like Justice B.N. Srikrishna, Justice A.B. Shah, and also a panel comprising of the IAF members, as well as other leading practitioners. After several rounds of review, additions, and edits, the IAF Best Practices Guidelines for Conduct of Arbitral Proceedings, version 1, was formulated. Today, IAF is proud to launch the updated version of the IAF Guidelines, that is, the IAF Guidelines version 2.0. This incorporates further inputs received over a period of time from various eminent jurists, including Justice Vibhu Bakru and Senior Counsel Dr. Saraf. The IAF will periodically continue to update the guidelines with the view to incorporate best practices. Now, some members of the IAF team that drove the above-mentioned process were Vyapak Desai, Raj Panchmatia, Mustafa Motiwala, Nusrat Hassan, Abhinav Bhushan, Tejas Karya, Shashank Garg, Umar Ahmad, Venu Parekh, Meenakshi Iyer, Nandini Khaitan, Neeti Sachdeva, Rishabh Gupta, Trisha Mitra, Chinmay Pense, and Mandavendra Kane. I invite each of you to peruse the process note contained in the IAF guidelines, which sets out the process and the team in greater detail. Now, with that, I request the moderators for today's session, Raj Panchmatia and Vyapak Desai, to take this forward.
Thank you, Sahil, for such a wonderful introduction to the IAF guidelines. Thank you, Justice Patel, Chief Justice Wazifdar, and Dr. Saraf for agreeing to join us for a web launch of IAF Guidelines 2.0. Can I request the IT support to please put the guidelines on the screen?
So we'll treat this as a web launch. And thank you everyone for this. Raj, you want to continue?
Yes. Before we start today's process, we thought that we will also thank our directors of IAF because IAF is also a company, and therefore we also wanted to thank our directors, Nusrat Hassan, Renu Parekh, Tejas Karia, Shashank Garg, who have been our directors for IAF. Sahil has already thanked most of our members, and some of them I thought we should also thank were Naresh Thakkar, Shanin Parekh, Shalaka Patil, Ankush Mehta, and Umar. Thank you all for helping us to come up with these guidelines. It's been a pleasure. It's my pleasure to introduce you to our panel today. Justice Gautam Patel, Chief Justice Wazir Dar, and Senior Counsel Mr. Virendra Saraf. I remember Justice Patel was part of the IAF launch many years ago at the CCI Stadium, where IAF was formally launched. And he was the one who was there and he inaugurated that session as well. Chief Justice Wazir Dar and Dr. Saraf have also helped us last time when IAF guidelines 1.0 was launched, and they were part of our process then. So I'm happy to say that we are in a company where we have full support of all of you there for the IAF team. With that, I open the floor to Justice Patel to say a few things about guidelines.
I'd yield to Justice Wazir and invite him to kick it off. I'll follow, if he doesn't mind.
Justice Wazir,
you have to unmute.
Your Lordship, you are on mute. Your Lordship, you are on mute.
Yes.
Right.
Yes.
All right. Well, Justice Patel, as a sitting judge, has always to be obeyed. Well, yes, I'm constantly reminded by people that you're only an ex-judge, so now that's it. Well, thank you very much, the IAF members of the committee, everybody, for inviting me to this launch. Let me make mine as brief as possible because we are all waiting for Justice Patel, who has taken me by surprise. You know, when I first saw a draft of these guidelines, it was about a year and a half ago, soon after my retirement, I was not sure at first as to the purpose of these guidelines. I was not sure what purpose they would serve. They don't have any statutory force. They are not binding between the parties. So what is the idea in just throwing up ideas or suggestions? Considering the enormous effort that has gone into preparing them, which was quite obvious, this is mentioned, in fact, in the process note. Sahil Kanuga mentioned about the 4 or 5 stages that you all have gone through, each of them extremely elaborate. And the number of professionals, most of them very eminent, who had put their input, who had contributed to the framing of the guidelines. From all this, it was obvious that it could not have been a futile exercise. And it certainly is not. I think it's necessary, firstly, to realize the importance of these guidelines. They do not bind parties, but they give a very good indication to the parties and to the arbitral tribunal as to the options that are available to them in arbitrations. I mean, I dare say that even the most experienced arbitrators would be aware at every given point of time about the development of the latest rules of procedure that are adopted by various institutions, as also which are adopted with modifications by various arbitrators. The IAF guidelines, therefore, must be seen as a very useful exercise in consolidating the combined effort, knowledge, and experience of institutions and arbitrators, as well as those practicing before arbitrators. Article 1, Clause 1 itself, I think, makes it very clear that the guidelines are to assist the parties and the arbitral tribunal to adopt a suitable procedure for the conduct of the arbitration. As we go through one article after the other, it is quite obvious that those who framed the guideline wanted to give the tribunals, parties, and the practitioners enough flexibility to choose the best possible option in a given arbitration. We all know that there are arbitrations, and what is good or useful as a procedure in one is not necessarily good or useful in another. Now, when you go to when there's an institutional arbitration, the institutions have their own rules of procedure. Parties also agree to abide by the rules of certain organizations, the Cotton Exchange, Stock Exchange, Grain and Free Trade Association, and so many others. But a majority of the arbitrations are ad hoc arbitrations. And in them, a majority do not provide for the parties being bound by any particular set of rules. I dare say that in these cases, which probably constitute the majority, the tribunals and the practitioners would do well to have a look at these guidelines before proceeding. Because we must keep in mind, considering the persons who have been interviewed, considering the research that has been done, that a lot of them are really a consolidation and a compilation of best practices. Now, somebody mentioned to me, and that was also about a year and a half ago, that if there are no rules, don't the experienced arbitrators in any case know what is to be done? True, I'm sure the more experienced arbitrators would know, but there is no harm again in going through guidelines such as these, which I know for a fact are going to be updated, and I'll come to that in a minute. Is that already time? Now, I think we must also remember that there is an attempt to not only permit, but to encourage people from other professions acting as arbitrators. Chartered accountants, architects, engineers. They may not be familiar with the options that are available, with the correct procedure to be adopted. When they have before them these rules, it may take them a couple of days to select the best, but that would go a long way in smoothing the process, which is bound to take more than just a couple of days. It is in this light that we must see the guidelines. Further, in these guidelines, the purpose of these guidelines, namely to enable tribunals to select the best procedure for a given arbitration, is clear from the fact that you don't ever find yourself bound down by one option, one or two options. There is flexibility. Further, since parties are not bound by these guidelines, they are always at liberty to modify them. Now take, for instance, your articles 23, 24, 25, 28, which provide for expert evidence. You may or may not select one particular procedure. In one of the arbitrations before me, it was suggested, in fact, that look, instead of wasting a lot of time in each party bringing in his valuer, which would have gone on for days on end with cross-examination and everything, because the quantum was high, why don't we just refer it to 3 arbitrators to be appointed either by the tribunal or by the court, and then take the mean of the 3 arbitrators? Flexibility is there. Now, having said that, this must be one of the few cases where, even before the launch of the guidelines at this moment, I guessed, and my guess is correct because it was confirmed, I think, by Raj Panchpatia and by Vyapak Desai, that the poor members of the IAF committee have already gone back to the drawing board when it comes to Article 29, which says that video conferencing should be permitted in exceptional cases. I think, considering the unfortunate situation that we are going through now, they may very well want to change Article 29 altogether. And naturally, they are already on the job. They have a huge task, and probably in the field of arbitration, at least for the next year, year and a half, and God forbid, I hope not more than that, this is going to be one of the most important endeavors, because you can't just have arbitrations frozen for such a long period of time. May I just, in a lighter vein, end by saying that some of these articles might even have to be, we must have a slight relook at it. You have advised that arbitrators should confirm as to whether they are available during normal court working hours. I think that question should also be put to the practitioners, if you don't mind. All right. Now, that's so much for sarcasm. My congratulations to all the members who have put in an enormous effort in framing the guidelines. And what is more important, the very nature of these guidelines require them to be revisited again and again. Keep it an ongoing process, because we all know that change is coming almost on a yearly basis. Once again, thank you very much for inviting me.
Thank you, Chief Justice Wazifdar. May I now request Justice Patel to say a few words.
Thank you. One of the great advantages I have is that I can just say I concur and stop right there, because there's very little that is actually to be added to this. I must say, first of all, thank you to all of you for inviting me here. And this is a marvelous job. I want to supplement very briefly what Justice Vazifdar has said. Just 1 or 2 comments. I do agree, taking the last point first, that some of this will need to be looked at given the current scenario. And on Article 29, there is a recent instance of a week-long trial with a witness conducted by a court in England. The precautions that they took while having that witness examined and cross-examined on a video conferencing link are instructive, because they made sure that there was nobody else prompting the witness. They had a complete delineation of what materials and documents and books he was looking at, so there was no extraneous material. The court record, therefore, remained uncluttered. Those are guidelines that should be incorporated. I think it's important to remember that though these are not binding like they would be in the case of an institution, they have an enormous utility, because they provide the one thing that is, I think, perhaps lacking in ad hoc arbitrations, which is some level of standardization and uniformity in procedure. This, I think, is actually cardinal. And one of the things that these guidelines like this will do, if they are increasingly adopted, is that it takes out one level of possible dispute about the procedure adopted. If the guidelines are good and more ad hoc arbitrators adopt them, then in a challenge or whatever it is that is going to happen to the final award, neither the court nor the lawyers are going to waste time on dealing with a procedural hiccup. I think that's important. Those are unnecessary distractions. The current trend in court is to minimize judicial interference. And you definitely don't want judicial interference because the procedure has become wayward or has gone off the rails somehow. In other words, it lets you narrow the challenge, and that's really what we should be doing. The other complication is built into the Arbitration Act, because when it says that strict rules of evidence and procedure do not apply, That's one thing to tell you what doesn't apply, but it doesn't tell you what does apply and what you ought to do. And it doesn't mean that you can jettison the whole of the Evidence Act or the whole of the Civil Procedure Code. And these guidelines actually fill that void. The statute in itself actually creates something of a twilight zone when it comes to procedure and evidence. And the sequencing of these is, I think, very important because it tells you what you should do at various stages. The annexures to these guidelines, particularly the calendarization and the Redfern discovery and inspection discovery of document schedule, is a very important inclusion. I think as ad hoc arbitrators begin to adopt this, they'll find it going faster. And finally, this is one thing that enables arbitrations to be brought in on schedule. You adopt these guidelines, you're sticking to time schedules, you've got a calendar, you've got a system that is known upfront and known and available to all. That clarity is essential to an effective arbitration being done in a timely fashion. The experts on video conferencing, as I said, is something that is going to happen, but with some degree of caution. There are some portions of this, as I have just discussed with the members of the IAF, that might require to be revisited, including the question on costs. And one of my suggestions would be that perhaps we should follow the parameters set out in the Commercial Courts Act, because there is a ready-made formula there for what are the factors that should be taken into account while awarding costs. And it's quite a measured kind of schedule there. I do hope that we'll be able to adopt more ad hoc arbitrators will adopt them. My question is whether it's going to be at all possible for a court, while in a Section 11 order, to say that you will have regard to these guidelines. If a court could do that while appointing the arbitrator in a Section 11 matter, then I think that would go a very long way to bring about that standardization and uniformity. Raj had given me 5 or 6 questions in advance by email. Do you want to address them now or after Dr. Saraf has finished?
So I think we will let Justice Dr. Saraf also finish, and then we will come back with questions to all of you.
All right. Thank you very much. For
thank you, thank you, Justice Patel. May I now request Dr. Saraf to say a few words, because he has been part of our IAF guideline 2.0, and in fact he has reviewed the guidelines for us and helped us with his comments, and we've troubled him a lot when we were coming up with 2.0 guidelines. Dr. Saraf, you're on mute. You're on mute.
Thank you so much, Raj. It's my privilege to be on a panel with Justice Wazifdar and Justice Patel. And I fully agree with what both of them have said. These guidelines can serve a great purpose in India. It's the fact that institutionalization is a need, we all agree. But the reality that we are far away from an effective institutionalization, and it will take some time, is also a reality which we all are aware of. So in the meanwhile, what we need to do is to strengthen ad hoc arbitrations and to ensure that the procedure followed in the ad hoc arbitrations are fair, so that ultimately the entire procedure, the award or the entire process of arbitration is not frustrated by a small error of procedure. I've very often seen very beautifully written awards and absolutely correct view taken being set aside because there was a big procedural lapse in the entire thing. And that is such a pity, because, you know, the whole thing is a perfect procedure. The parties have gone through it. And then the award has been set aside because of a procedural impropriety. And as Justice Wazifdar said, we do not only have arbitrators who have a judicial background, we have arbitrators without a proper judicial background also, who are not familiar with how this entire procedure should go ahead. And with utmost respect, we also have people from, including lawyers as well as former judges, who've not had too much of an experience in original proceedings. So they themselves are a little unaware of how entire thing of recording of evidence and how the procedure should go ahead. And in that bargain, there are at times errors committed. I've seen arbitrations with seasoned people the awards, where in the award itself it is written that in the midst of cross-examination, the arbitrator said, I have understood the case now, nothing further is required, and called the stenographer and dictated the award. Now, it might have been a very correct view, but it rendered the award vulnerable. We have had a situation where seasoned arbitrators have relied upon documents given by one of the parties to him formally by an email after the closing of the arbitration. That might have been an immaterial document at times, but the reliance on that makes the arbitration vulnerable. So at every stage, if we can safeguard that the procedure and make sure that there is no error in the procedure, that the procedure as contemplated in law is followed, and the entire procedure is fair, which would stand scrutiny in court, then that can go a long way in strengthening ad hoc arbitrations as an effective institution. And these guidelines almost give a step-to-step guidance for arbitrators, particularly arbitrators who are not with a judicial background, who are not from the legal field. It can go a long way in streamlining those arbitrations. So that is a very helpful guideline. Only thing that I think we'll also be discussing this is it needs to be popularized. It needs to reach to the grassroots, because that's where the need of these guidelines is much more. It needs to reach to the grassroots level arbitrators so that those arbitrations do not suffer because of lack of procedure. But otherwise, a great effort, and the guidelines are a great product. Thank you.
Thank you, Dr. Saraf. In fact, we need to thank you for helping us with putting this guidelines together. And thank you very much for assisting us. With that, can I then first ask one question to you, straight coming from the last point that you made, that we need to popularize and make awareness about these guidelines. How, in your view, we could work towards popularizing these guidelines, say in a tier 2 or tier 3 cities? How could the Bar Association of various courts help us in popularizing these guidelines in various courts?
Raj, the first step today is the first step for you to popularize. I don't think you've had an event, even at the launch of the first one, where you had almost over 300, 400 participants, and with many more hearing on a Facebook streaming. So today you have these many people knowing about your guidelines. Similarly, today there are so many platforms, apart from the bar associations. Of course, we can tie up with every courts bar association, every district courts bar association, and reach out to them. But today, even on an electronic platform, there is such means of popularizing. It reaches so fast to people that that's a first step today, and the easiest way to popularize these guidelines. Then, of course, you have to tie up with the bar associations, the various institutes, the Institute of Chartered Accountants, the Institute of Engineers, all these institutions such as Silk Merchant Association, Cotton Merchant Association. Reach out to all of them and make sure that all of them have these guidelines in hand. And apart from these guidelines, I feel a step which should be taken by IAF, which will go a long way, is to initiate training courses for arbitrators. We may not need it for seasoned arbitrators in a city of Bombay or Delhi, but it will surely go a long way if we initiate small courses of training of arbitrators, or even release small videos of, on how to handle different aspects of arbitrations. That will popularize IAF as an institution, and consequently the guidelines also. So this is very necessary if we want these guidelines to succeed.
I think these are very, very important points that you mentioned, and we will definitely work towards it to popularize the IAF guidelines, and we will seek your support whenever required. One more question before I go to Justice Patel is, you mentioned that lack of procedures sometimes get fatal to the award, and if the procedures are not complied with properly in the arbitration process, the awards tend to get set aside. How important do you think guidelines like these would help in bringing some sort of a standardization in the entire arbitration process?
Raj, as I said, there are sometimes absolutely unintentional errors committed by an arbitrator which render an award vulnerable. Like your guideline says something as basic as, please do not communicate with any party without the knowledge of the other side. Now, usually a person who's a lawyer or a judge knows this. But an arbitrator may write an innocuous couple of emails with the other side, and later on that email gets copied to some other side, and that becomes a big ground for challenge to the award. So it helps. These guidelines surely help a great deal on how to handle an arbitration on a day-to-day basis. As I said, I have come across very seasoned arbitrators. There was a matter where there was an issue of an actress not being able to, act in a play, and the producer suing her for damages. And in that case, the defense of the actress was that she had migraine. And therefore, as a result of that, I could not act. I suffer from migraine, so the lights affected me. So after the entire arbitration got closed, the learned arbitrator did his own research on migraine on the internet and inserted in the award great deal of material about how migraine affects the functioning of a person. And ultimately, I mean, though we succeeded before Justice Wazifdar in a single judge, finally, the matter got settled. The parties had to come down to an appeal court. There were issues and matter got settled. But these are errors which are unwarranted, which could have been avoided. And they render a beautifully conducted arbitration, so much of effort of both parties as well as the arbitrators, they really go waste. And that really also defeats the faith of people in arbitration. So these guidelines, if followed in spirit and molded as per requirement, can surely go in making arbitration a much more transparent and effective means of resolution.
Thank you, Viren. Justice Patel, if I could now come to you. In India, traditionally, we've seen that people are used to ad hoc arbitrations and people are not so keen about institutional arbitrations. What, according to you, still pulls people towards ad hoc arbitration and not institutional arbitration? So much.
Simple answer to that is that when parties agree, and there is some form of agreement that happens even in a Section 11, even if they say they leave it to the court, they know that the court is going to pick somebody they can trust. It's a question of being able, familiarity, knowing the person, having confidence in that person, the known entity. We know that so-and-so lawyer is good, has a good practice, has a good knowledge of the law. The institutional arbitrations tend to be faceless. You're leaving it to a body. You don't know who will be appointed. You don't know who will come. You don't know what kind of a rapport you'll have. These are impediments faced by both parties and by their engaged lawyers in readily agreeing to institutional arbitrations. Now, when your contract itself names the institution, then it's a different matter. You don't have a choice there. But when you ask people to go through an institution, this is where institutions stumble. That's really the stumbling block. It's that familiarity with the arbitrator.
Okay. Then taking from that, then you're also...
Which is why Justice Wazifdar has no time. Exactly.
So let me come to Justice Wazifdar, maybe if that is the right time to come to him. If Justice Patel has, given that cue, I think one very valid reason why we came up with this idea of guidelines was we never wanted to cut across or overlap with either the law or the rules of any institution, because the law and institution at the end of the day says that arbitrator and the parties are free to choose how to conduct the arbitration. So ultimately, even if it is under institutional rules, and that is why the guidelines are actually read, reviewed, vetted, and supported by institutions like SEAC, ICC, and MCIA. So that is never a conflict in that sense. But definitely it is helpful for ad hoc, and it can also be helpful for institutional so far as bringing in the consistency. So if I come, I think Justice Wazifdar did talk about how he found it helpful on the second read rather than the first read when we met him in 2018. What is your view, sir? can we have any other way or method in which we can convince the parties or convince the arbitrators to adopt this, irrespective of what law or what institution rules that may apply? Because what at the end of the day these guidelines bring is consistency in the conduct of arbitration, including certain draft procedural orders, the awards, the red fund schedule, and the manner and method in which case managements can be done, and so on and so forth. Do you think there is any downside? If there is no downside, then how do we, push this little further to bring the real aspect of consistency?
I think the answer is almost it's embedded in what I had said in my opening. Look, the advantage that you have in these guidelines is not merely consistency, because that misses the real purpose of these guidelines. These guidelines are a storehouse of knowledge, and it gives you not just consistency, but along with consistency, it gives you flexibility. When you agree in the beginning to abide by a particular set of rules, then you do not have that flexibility unless it is by consent. Here you can have that consent right in the beginning. So in that sense, Vyapak, these guidelines serve a purpose. And one of the most important things I find is it is purely consensual. People opt for it because for that particular arbitration, it is the most suitable. And there can never be a downside to guidelines like these, for the simple reason that it is bringing forth before arbitrators, and I keep repeating, no matter even if they are experienced, when you have this kind of a storehouse, it is always useful for anybody.
Sure.
And there you have the advantage of a coordinated effort between the tribunal and the lawyers who are appearing before the tribunal to select your method.
Sure. So,
and I don't think that you're cutting up. I don't think you have to feel embarrassed about cutting across ad hoc or institutional arbitrations. I don't want to go into which is better. I steer clear of that always. It does not affect either.
Sure. Yeah, over to Raj.
So Justice Patel, taking a cue from what Justice Wazindar said, that he doesn't have any view on either ad hoc or an institutional in that sense, which is better. But as a sitting judge, when matters come to you, say from an ad hoc arbitration or from an institutional arbitration, the awards that come to you in a 34 petitions, would you see a difference when an award comes from an ad hoc arbitration tribunal or an institutional?
No, not at all. Not at all. Ad hoc arbitrations, I have even from some very young lawyers at the bar, I mean, seriously outstanding awards of the highest caliber, beautifully written, beautifully reasoned, impeccably done. I don't think there is this kind of a very clear-cut divide or a distinction to be made that institutional awards are always superior to ad hoc awards. I wouldn't make that distinction at all. I actually have a question. I'm wondering whether either Dr. Saraf or Justice Wazifdar would like to weigh in on this. When I'm making an order under Section 11, suppose the order was to say that parties agree that they will have regard to the IAF guidelines, except to the extent that in the first hearing before the arbitrator, they agree that some of these guidelines will not apply. Would that help? Would that be useful in setting out a framework and a known framework? Because you don't have to reinvent the wheel then. It's been done for you. Would that be at all useful? Then they go before the arbitrator and say, okay, we don't want this, we don't want this, we're okay with X, Y, Z, and we'll follow the rest of this. Can that be built into an order? Would that be useful?
That to me?
Yeah.
let me think about that, Justice Patel, and I can share that view.
No, I'm asking whether you as the arbitrator would find it useful if you got an award saying that here are the guidelines, have regard to them. Whatever the parties and the arbitrator feel they don't want to use, reject those, keep the rest. You don't have to reinvent it.
I'm just wondering, Justice Patel, with due respect to you, would it make a difference? I can have a look at it either way. I mean, the only purpose that the order would serve is that it it just gives people an idea that there are such guidelines. Otherwise, it's always open to arbitrators to select whichever ones they want to. People should not also misunderstand.
No, I'm just saying from the point of view of focusing attention on there is an existing set of well-articulated guidelines, and why not just invoke those?
So
Since it can't be mandated.
Apart from the
Sorry.
fact that they are being referred to seasoned arbitrators who are former judges and who are very senior advocates, to junior lawyers and a lot of other people, this might help. And it could be modified, as you said, by the arbitrator in consultation with the parties. So it's like a blueprint of the procedure.
That's right. That's all I'm saying.
Given them. So apart from, and matter to matter, considering the arbitrator you're appointing, and particularly if they are young lawyers and they are persons from non-judicial backgrounds, surely can be done, I would believe so.
Okay, we've got a bunch of questions, by the way. Here.
Yes, we have a lot of questions. So, Vyapak, you want to just take
yeah. Before that, we also wanted to run us because we wanted participants also to, have some say in this game. We are running a small poll and we are trying it out online. And the first poll, can you run the first poll? The first poll is, what is your preferred mode of conducting arbitration, ad hoc or institution? Everyone on the participant list can actually select one of the answer and submit it. In fact, possibly speakers can also do that. This is a little random general poll, but just to get a sense out of few hundred participants here, what is the kind of answer it throws up. I think, okay, so 67% of people still say ad hoc who are part of this the webinar, and 33% say institutional. So,
but Vyapak, you didn't have a nota response. None of the above.
Maybe
I don't have a preference.
I know. Okay, so maybe next time this is a learning for us. Next time we'll also give that preference or that option to the participants as well. So with that, let me take a couple of questions which are already there on the question answer too. Unless if the panelists have already seen some of them, and if they have a preference to answer any of them specifically, I can pick a couple of them.
There's one question directed directly to Justice Patel.
Yeah, I will.
Yes, from Mr. Badiani. I've got that.
Justice Patel, you want to take that?
Yes, I'll read out the question. You mentioned about the UK court conducting a trial. I attended a webinar by a UK law firm on virtual trials in court and arbitration proceedings. The speaker was Mr. So-and-so. He had conducted the virtual trial in the UK. His view was that the basic requirement for the success of a virtual hearing is the infrastructure and availability of technology. With the situation prevailing today, I feel that there are at least some stages, both in arbitration court proceedings, like procedural hearings and appeals, as mainly issue of law is to be decided. What is your take? I agree, but there's no doubt that you need a stable, dedicated platform to do this. I'm not talking about any particular app or software, but let's be clear about one thing. All these apps that we're using are actually suboptimal. None of them was designed for a litigation system, let alone a court system. They've been designed for corporate presentations, webinars, seminars, and so on. Now, what's happening is that we are adapting our workflow to a corporate culture software rather than having a software that actually is designed to assist and replicate our workflow in the digital world. Now, we need to have some sort of application that very closely mimics what we do. It has to be clear. Now, take an example of a witness being cross-examined. A camera like this, which is up close and personal, does not actually tell you what he's reading and what he has in front of him. We have to have some mechanism by which the tribunal, whether it's a court or an arbitrator, can see what the witness has without other people having to be in front of the witness. How do we do this? There are all kinds of procedural issues there. We do need to have this in place. Otherwise, it becomes problematic. Certainly, the technology is required. Without that technology and the infrastructure and the hard infrastructure, the internet connections, this is going to be very difficult. You can't have court hearings that break down because of a overload on the system or whatever. What's the next question?
Sure. In fact, if I may add a little bit there, and as we were discussing earlier, I think one is to see court hearings and arbitration hearings a little beyond video conference. In fact, there are softwares and there are platforms available, including CODR, which is supporting the technology for this webinar, where you can actually create hearing rooms, and they are meant to have pleadings part of the hearing room. Everybody can see it. Nobody has to go around 2 different computers or 2 different sessions. You can look at the pleadings. You can even on the go file your dates and events or written submissions or judgments, and everybody can see it. Even after the hearing, that remains open till the time judgment is passed for the parties to look at the documents filed. You can record those hearings and everything remains intact. It's like a room for that case. So there are many such options available. I'm sure the institutions, including the courts, would adopt a more specific and more platform,
No,
which is
I'm sorry to interrupt. That's not what I'm talking about.
Sure.
The institutions, the chambers of arbitration do have those. I'm saying that if an ad hoc arbitrator needs to do it, he must have an affordable, stable technology to be able to do it. If Dr. Saraf is an arbitrator or Justice Vajiddar is an arbitrator, needs to do it, that technology must be equally available to him as it is to MIAC or anybody else. That's the only point I'm making.
Sure.
Okay. What else have we got? Oh, interesting. I think, Justice Vajiddar, this is for you. What is your opinion on a possible cap on arbitration costs, including arbitrators' fees? That's entirely Justice Vajiddar's domain. I have nothing to say on the subject.
May I, under the threat of contempt, avoid
decline to answer? Yes, all right, we'll pass over that.
I think there is one for Dr. Saraf. If in his understanding of these guidelines, there is any possibility of an interplay of this with institutional rules, thereby making these guidelines useful even in an institutional arbitration. That's from...
I would believe surely these guidelines can be utilized even for an institutional arbitration, so long as any of the rules of the institution are not in conflict with these guidelines. Usually they would not, because these guidelines are more in the nature of a best practice kind of guideline. So effectively, largely, this would not be in conflict and they can easily be adopted. But of course, if there is a particular institutional rule which overlaps with these guidelines, then the arbitrator will have to apply his mind and give primacy to those rules over these guidelines. But otherwise, surely these guidelines can be adopted.
Sure. Thank you.
And just a point on the cost of the arbitration, let me answer this, that very often it is the arbitrators who are blamed for an increasing cost of an arbitration. I would believe that the members of the bar are equally responsible for an increased cost of arbitration. So it's apart from, just saying that arbitrators have increased the cost of arbitration, I think each one of us should take that responsibility. Each one of us seeks an arbitration in the evening at 5 o'clock, rushes in at 5:30, and by 7 o'clock is in half a mood to wrap up. And then when the hearing is charged, the arbitrator surely cannot be blamed. He's been very ready to give you a daytime hearing, which most often lawyers discourage. So the whole cost of arbitrations increased. All the stakeholders are responsible in that process. So if the cost of arbitration need to be curtailed, then every stakeholder in arbitration needs to exercise that responsibility.
Sure. Justice Wazifdar or Justice Patel, and including Dr. Saraf, there's one question on the proposal of Arbitration Council of India in 2019 amendments. I think there is a question as to what is your view in terms of its effectiveness and how it will work in tandem with the arbitration process itself. I would leave it to any of you if you want to answer that.
I'm not commenting on that.
Dr. Saraf?
I think the best thing is Dr. Saraf takes that one.
Oh, why, sir? I
I'm at liberty to do that.
I really believe that the council will render more bureaucracy to the process of arbitration. The whole council and the whole way it will operate will lead to a whole lot of complication in party autonomy and the manner of functioning of arbitrations. I don't believe. Let's see how it unfolds. If it does a good job and serves a good purpose, good luck to all of us. But considering the frame of the 2018 amendment, I don't see how that will further the cause of arbitrations in India.
Sure. Thank you. I think we wanted to run the second poll also. So we have still about 10 minutes before we ask other questions. But Vikas, can we run the second poll on do you think arbitration hearings can be conducted effectively online? Again, generally from the few hundred people who are participating. Okay, it's a close 50-50, 49-51. So I think still a lot has to be done to bring in the confidence to do an online arbitration. So a lot of work for all of us, if at all this kind of a situation under COVID continues little longer. Raj, you want to take up the other questions?
One interesting question from Advocate Kapse, who says that he practices in Kolhapur, does arbitration and works as an arbitrator. Is it necessary to record a proceeding if he conducts an arbitration by video conferencing? Now, we know that there is no such mandatory requirement, but what are your thoughts on that? I mean, I don't have any particular
Asking.
Well, I'm just anybody who has a thought on this, because that's a question that I thought was of some interest. Is it prudent? Is it required that he conduct whatever hearings he has, that he should record them?
Want me to give it a answer that? Look, I'll tell you, as an arbitrator, or if I frankly, even when I was a judge, I had no problem whatsoever in that. But when it comes to arbitrations, I think primacy must be given to the parties, because arbitrations by their very nature are confidential. Parties go to arbitration, of course, because for a variety of reasons, one of which is the confidentiality. So unless, I would say if either of the parties does not agree, then we should avoid it, because ultimately the arbitration is for those specific parties and not a general litigation.
That's correct. There is,
I do want to sound a word of caution about one of the inherent perils of video conferencing. You know, we have a hearing, the authority passes the order. Two things are possible. It's always possible for one of the parties to say, I don't want to do this by video conferencing. I want to be heard in person. I don't see how you can compel it. That's one. We don't have a governing statute to do that. That's first. Second, there is the other precaution to be taken, which is that the order comes, the party finds that it's an adverse order and says, I was not heard, I could not be heard, the connection was bad, you didn't hear my submission. That's an additional complication and a wrinkle in this fabric. So caution is all I'm saying there.
So you missed out the situation where a lawyer, when he's losing a matter, suddenly say bad network and disconnects.
No, but I do want to say, Dr. Saraf, this one point that you made about arbitrators, counsel wanting to be both in an arbitration and a court. Personally, I think it's appalling, and I think we just must, as culturally or philosophically, recognize that arbitrators are really doing the work that would otherwise have to be done by a court. And courts must, I think, start giving allowance for a counsel who says, I'm not available, but because, or somebody else will take over, I have to be before the arbitrator, because that's a matter too. It's just on the board of a different forum. You can't just say that it's unimportant, be here or else. And the counsel can't say, I want to do this and I want to do that. Now you have to choose. Otherwise, we're just going to be dealing one or the other. You can't do both at the same time. That's the whole point.
I fully agree, sir.
So there are many questions still, but we are close to 5 p.m. and I know everyone has commitments. So maybe unless we have any final comments, we can take the questions offline and then hand over to Manvendra for vote of thanks.
Yeah, before we close, one point that I wanted to ask each of our panelists was that one recommendation each from each of the panelists for IAF. Justice Patel.
Recommendation in what sense?
What can IAF do next? We are working on a protocol to come up with
version 2.5. No, I'm serious. This is a work in progress.
Yeah.
Yes. We are also working on a
change with times.
Yes, we are also working on a video conferencing. We are working on a video conferencing protocol for which IAF is working on, and that will be launched soon as well. And we are working on that. And of course, this is work in progress for us, and we will come up with 2.5.
I have only one suggestion.
Yes.
That this is what I mentioned even in the beginning. It's a work in progress. It is an ongoing exercise that the momentum has to be kept. Only one thing request is, when you are finalizing your video conferencing thing, please also check up with the practitioners, because what may be necessary in India may not necessarily be necessary elsewhere. There are certain other ways in which you can do it also. Like multiple rooms, because let's face it, it's not just a question of video conferencing, it's video conferencing with today public safety also. We might have to come to a stage where I don't think we can start being at, very close to each other for a while in any case. Certainly not the retired people, because they are under greater danger. There might be a necessity of having a video conferencing, not just in the academic sense as to how you do it and how to see that the witness does not have a certain documents or he's not being prompted, but also from other points of view. So just check up with practitioners before you finalize. That's the only, I'm sure you will do it. I just took the liberty of saying that.
Yes, we will run almost the same process which we ran for the IAF guidelines. Dr. Saraf, any comment?
My suggestions are mainly to popularize these guidelines, initiate training programs for arbitrators. Please start something whereby these guidelines can actually be explained to arbitrators, and even the legal provisions of Arbitration Act, which an arbitrator should bear in mind while conducting an arbitration. That is important, and maybe we can also come out with an IAF guideline which is more specific to India, where you can also include guidelines of how arbitrators should make disclosures as required under the Arbitration Act, and what precautions the arbitrators should take. Because if you want to reach these guidelines to a grassroots level arbitration where there's more need for these, then these will help.
Sure.
Manvendra, over to you.
Sure. Thank you, Raj. Good evening, everyone. On behalf of the Indian Arbitration Forum, I would like to thank Justice Patel, Justice Wazifdar, and Dr. Saraf for gracing today's function for the launch of the second version of the IAF guidelines for conduct of arbitration. Thank you, sirs, for your valuable insights and guidance, with particular emphasis on the standardization and uniformity in procedure, as well as the flexibility to choose the best options in arbitration proceedings. I'm sure everyone will benefit from them. And as Justice Patel and Justice Wazifdar both rightly said, that some of the articles will have to be looked at, and we will be definitely doing so. So thank you so much for everything. I would also like to thank all the supporting organizations and of course members of the audience for participating in this function. And I'm confident that the IAF guidelines will assist all the arbitration practitioners for adopting the best practices in conduct of arbitration proceedings in India. So thank you everyone and have a lovely evening.
Thank you.
Thank you so much.
Thank you, sir.
Thank you.
Thank you.
Thank you.